back to the Environmental Law Monitor. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Group. We're glad you're here with us today. My name's Daniel Pope. Today's topic is managing environmental risk in the transactional context. You know, one of our goals with the monitor that we've said from the beginning is to have conversations not just about new developments in environmental or natural resources law, but have conversations about aspects of making decisions around the ways environmental risk shapes all of our activities. And that can range from a merger and acquisition and includes other kinds of transactions. Today, we're going to be focusing on environmental reps and warranties, environmental insurance, and reps and warranties insurance. And it's a good thing that we're recording remotely today because we've got 4 special guests with us today. I don't think that we could fit into a recording studio even if we had one. We're joined today by Tim Wilkins in the Austin office, Tony Visage, a new guest of the Environmental Law Monitor, joining us from Bracewell's Houston office, and 2 special guests, Michael McGinn and Adam Wilhite from Marsh. Mike, Adam, why don't you share with us a little bit about what you do at Marsh and how it relates to navigating environmental risk?
Daniel, thank you so much for welcoming us and on this call. Really looking forward to it. My background and Marsh's background, I'm one of the key leaders of our environmental risk team. So we get very actively involved with outside counsel like yourself when there's a deal that comes down the pipe, and working closely with Adam's team on the overall M&A side. We kind of handle the environmental risk components and look to see if there's a bespoke environmental insurance solution that could be laid on top of or in tandem with the reps and warranties or M&A insurance. And that's kind of where I support the team on.
Yeah, thanks, Mike. And my role at Marsh is on the transactional risk team. So I, in large part, place rep and warranty policies, as well as look at other potential one-off bespoke risks. But by and large, rep and warranty policies.
We're excited both of you are here with us today, and thank you for joining. We're looking forward to a lively discussion on these topics. One of the first things I wanted to talk about, you know, we've mentioned environmental insurance, we've mentioned reps and warranties insurance, but when I started at Bracewell, the first thing I encountered was, I guess, what you would call the traditional framework for managing environmental risk in a transaction, which is that you would have some reps, some warranties, and then you would usually have some kind of indemnity framework in a transaction. Now, of course, even in environmental law classes at law school, they're not talking about this. So I've been sort of picking it up as I've gone along. And then I started to encounter reps and warranties insurance, and I started to learn a little bit more about environmental insurance as well. Michael and Adam, why don't you kind of break down these frameworks for us, and maybe Tim might assist there. But I'd love to know more about when reps and warranties insurance started to become more popular, and sort of what the market looks like now. How many deals are using the traditional framework as I've described it? How many people are starting to make more use of environmental insurance or reps and warranties insurance?
Sure. And the way you framed it is a very useful way of thinking about rep and warranty insurance, because your starting point in the legal world was in looking at the more traditional set of representations and warranties with an indemnity structure, with the seller providing an indemnity to the buyer for the risk of any potentially breached representations or warranties. And as you probably saw, that indemnity was very often backstopped by an escrow. Now, I underscore that it actually is extremely useful that you started with that framework, because as I speak more and more with attorneys, it's interesting that a lot of much younger attorneys at some very large, prominent national law firms have literally never worked on an indemnity deal a couple, 3 years into their career as lawyers. I find this fascinating. I have a background as an M&A attorney. The vast majority of deals that I did prior to joining the rep and warranty field were all indemnity deals. But it's gotten to a point now where, to your question, a very large majority, especially of certain slices of the M&A world, are using rep and warranty insurance. So speaking in broad strokes, and we can really kind of only estimate as data just continues to evolve, but it looks like over half of all middle market, and I'm using a fairly broad definition of middle market there, private transactions are using rep and warranty insurance, and it does look like that is trending upward. With room to grow, you look at other jurisdictions in Europe, Scandinavia, Eurasia, we're seeing the product used on upwards of 70% of all transactions. And who knows? It could hit that here in the US.
Well, I've actually got a question about that. You said that that's kind of happening internationally. Is that just because it's a little bit more manageable to have a rep and warranty insurance framework across international boundaries? Maybe you're not worried so much about the nuances of legal regimes, and you can have a policy that works across the borders. Why do you think that's happening? That's pretty interesting.
Yeah. So in European deals, I think it's a slightly less litigious environment. In the US, I'm sure it won't surprise your listeners to hear that we tend to be a little bit more likely to sue, or perhaps a better way of saying it is that we have a legal framework that gives plaintiffs more rights than in other jurisdictions. So, you actually saw the policy adopted more quickly in other jurisdictions. The U.S. on the international scale was a little slow to pick up the rep and warranty regime. It actually wasn't until the policy made a few improvements that the concept of using rep and warranty insurance really caught on. But the purpose of it really is to put the buyer in as close of a position as possible to what they would have had they gotten an actual escrow, that structure that you were initially introduced to when you started your career here. We can explore kind of some of the nuances and differences there, but the idea is to put the buyer as close as possible to the position they would have been.
The way Adam just kind of outlined it is exactly how we tackle these M&A deals. It starts with the M&A structure, and then you go down and see what are the key issues that are part of the deal. So obviously a heavy industrial deal, heavy oil and gas deal, manufacturing deal, you're going to have environmental issues that get kind of pulled out of that. And when that happens, Adam and his team would reach out to our team and say, hey, look, this issue looks pretty daunting. It's probably, the reps inside the traditional standard are going to be just things like compliance reps, very standard, very vanilla, but they're not going to cover significant potential tort liabilities and environmental liabilities. So therefore, we now go into the environmental insurance world, and in tandem with the reps and warranties, look at developing a separate standalone policy based on limits and needs and et cetera. So we kind of work hand in glove to make sure there's no real exclusions there, and that the buyer does have what they need to be good about making the deal go forward.
So you end up tailoring your specific approach to sort of the facts on the ground, it sounds like.
Absolutely. And just to add to another thing on the metric side that Adam touched on, the policy, reps and warranties policies came out, I guess, 10, 12 years ago, and was principally a sell side deal. And the private equity folks were driving the bus. Now it's pretty much a 50-50 split between the strategics and the PEs. And it's always the buy side that's really making a call on what insurance is going to be placed and different terms and conditions, and working with folks like us at Marsh to do that.
That corresponds with some of what I've seen too in my limited time as an attorney. I've always seen it more of a buy side purchase. And so that's how I've seen it. I am coming in a little bit more on the tail end of the adoption of reps and warranties insurance. And Mike and Adam, could you talk about some of the driving forces a little bit behind the adoption of reps and warranties insurance? Give us a little bit more flavor there.
Sure, absolutely. So picking back up on the timeline there, around 2009, 2010, in the wake of the financial crisis, as M&A deals started to pick back up with the economy recovering, the product started to grow significantly. I think in part, the product had finally gotten to a point where it was palatable and marketable to a U.S. audience. Its starting point was with a certain number of exclusions that came over from the European markets that just weren't palatable here in the U.S. And once it had gotten there and the U.S. legal community had gotten their arms around it, it became a bit of a no-brainer in certain circumstances. The way I think about it is that demand for the product is largely driven by the seller. When the seller puts themselves up for auction in the traditional auction process, they have a tremendous amount of leverage over shaping that transaction prior to signing a letter of intent. And in doing that, one of their goals is to maximize their walkaway proceeds from the transaction. And another goal would be maximizing the time value of money. So the escrow it presents risk in the sense that the buyer can access it in the event of a breached rep. But even if they don't, they still don't want their money sitting there for a year or 2 years.
Doing nothing for them, right? Just sitting there stale.
Yeah, exactly.
Got it.
But you're seeing the product being used in much more context than that as well. The deal community, I don't want to say has universally adopted it as the way deals are now done, but it's getting closer. I will say, though, that it's much more broadly accepted, and sometimes, very often, in fact, we're seeing the deal used on non-auction scenarios, often in situations where the buyer is trying to make the deal look that much more appealing to the seller.
And just to add to what Adam just said, Daniel, compared to environmental insurance, which pretty much came in existence in the late 80s, 1980s, that is, came basically from an exclusion on a general liability policy, basically spawned a whole market, environmental insurance. And often it was incredibly expensive and incredibly limited. The first couple of years it came out in the late 80s, only people that really purchased it were, basically landfill operators that had to evidence insurance, and that was the lesser of all evils. And then it evolved really extensively in the late 90s, early 2000s, and then matched up to really help on a transactional basis before reps and warranties really came into play. So it's kind of been there, and then it really kind of has its own little, situations where it helps more often when a company just wants to ring fence their liabilities, protect them for adverse development, et cetera. And then when they would try to sell off a operation or buy an operation and there was some risk, they would use environmental insurance in that context. So that's kind of sets it up. And then, now it evolves now to what Adam said, where when you have a deal, reps and warranties is kind of the overarching play. And then environmental is one of the different disciplines like tax and other issues underneath that you need to just kind of underwrite and get comfortable with.
Yeah, Daniel, this is Tim. I think that all of these are really important points about how insurance is used. I think thinking about insurance from the transaction lawyer or the transaction team's perspective, if you have a seller who's getting ready to divest of an asset, especially if there's somebody who's in the business of buying, fixing up, and flipping things, they don't want any long tail liability hanging on afterwards. They want to sell that thing and they want to walk away. And, if I'm buying something from somebody else, I'm sort of concerned that I'm buying their problems. I don't want to buy their problems. When you reach this impasse where the seller is saying, I want to walk away, and the buyer is saying, I want some protection, insurance is this product that sort of injects itself into the center and finds a way that everybody can pay a little bit or, get a little less money, but you end up with the protection being outsourced to a third party. It really has been an excellent way to get deals done, both from an environmental insurance perspective, but also the RWI.
Yeah, I was going to add, Tim, that's very well said. And one of the other positives about environmental insurance is you can get up a 10-year term policy and then get it so that it renews. So to your point about basically putting some good capital in place to get something off your balance sheet, 10 years is a pretty good long period of time to figure out what you did buy or what you did sell. The other party can figure that out within 10 years, and then you can always renew the policy. So it really does give you that kind of sleeping insurance, so to speak, and protection.
And that may also free you up. Sometimes, under the classical approach, or what I've been calling the classical approach, the traditional approach, those indemnity frameworks have usually a shorter lifespan than 10 years. It could be 18 months, it could be 3 years, but you've got to get going if you've got a shorter time period in which you can actually make an indemnity claim, right? And so a longer term insurance product may assuage some of those fears that you might have of getting underway and really wrapping your mind around and wrapping your arms around a set of issues at a site that you've acquired.
Yeah, absolutely. I mean, environmental's 10 years, and then in Adam's world, the 6 years term for some of these things is well in addition to the 18 to 24 months that you just mentioned, Daniel.
When I think about environmental reps in a traditional deal, whether it's indemnity backed or whether it's RWI, the types of reps that we expect a seller to make tend to go to things like environmental compliance. Are you complying with the regs? Do you have your permits? Are you complying with the terms of permits? Environmental conditions, like contamination issues on site, claims, whether those are enforcement actions or whether those are tort actions, whether those are off-site cleanup liabilities, things like that. And then there's certainly, especially in equity deals where you're stepping into the shoes of the seller, reps about contractual liabilities or other successor liability concerns. Those are things that, ideally, if there's a breach, they're going to be covered in some way. In the traditional indemnity framework, the seller would indemnify the buyer from those things. You might think that, reps and warranties insurance, they're going to directly cover those breaches. The insurer, rather than the seller, covers those. And I think that it's a lot more nuanced than that in the actual RWI world.
Yeah, that's right. And you drew some important distinctions there between claims, potential contamination, and compliance with law, 3 C's, if you will. Because coverage under rep and warranty policy will differ across those items depending on the sector that we're in. To be perfectly candid with you, as much as I want people to be using more and more rep and warranty insurance, which, by the way, with M&A volume being what it is this year, I'm actually not sure that's the case. I think we're plenty busy this year. But I'm sure that'll change. When it rains, it pours, but then, we all go through the slow period. But anyway, rep and warranty insurance carriers respond to environmental liability differently depending on the sector. When you've got a rather straightforward, middle of the fairway, low environmental risk deal, you won't see any environmental exclusions, but that really shouldn't surprise anyone because there isn't much environmental risk. The problem is that rep and warranty insurers just aren't that well suited for underwriting environmental risk, or rather, they understand that their environmental colleagues simply are better suited for underwriting environmental risk. So when you have a deal that has some more significant environmental risk to it, what you'll typically see is that with respect to contamination, the rep and warranty insurance policy will simply set what's called excess of and no broader than any underlying environmental insurance. So in other words, they're not going to underwrite the environmental risk. They will expect an environmental insurer to underwrite it. And to the extent there's any exclusions in those policies, the rep and warranty insurance policy will similarly follow those exclusions. And additionally, rep and warranty insurance is, in broad principle, designed to be a source of first recovery in the event of a breach. In other words, if you've got a breach of any rep, even if it would otherwise implicate the target company's insurance, the rep and warranty insurance policy can be recovered from first. And then, the insurers themselves on the back end, they can go subrogate against the insurers and figure out who eventually should pay. However, you, the buyer, can have basically a one-stop shop with the insurer. Now, with this excess of and a broader concept, though, that changes. You with environmentally sensitive businesses see that coverage position fairly frequently.
I couldn't have said it better. Yeah, Adam, thank you.
Yeah, Mike, tell us a little more about how the environmental coverage works, where in the heavier industry, higher risk environmental industry deals, RWI is of more limited applicability. How does the non-RWI environmental insurance fit in?
Yeah, I mean, basically, like I kicked off the call, we're going to approach the deal specific. And as whether it comes into Adam through outside counsel or I get a call through outside counsel on environmental, we'll try to bring it together. But once we quickly realize that, hey, they've got 25 sites, they manufacture this, or the chemical business or aluminum, whatever, you're just going to know by that business and our experience that they're going to need to have a standalone environmental insurance program in concert with the reps and warranties. So we'll work with counsel to make sure we've got the information we need, and then we would secure different environmental insurance options, limits, deductibles, et cetera, and then bring that back to counsel and the client to make sure that, okay, this is good. This is where we can really transfer the risk, or when we buy the company, here's where we can protect ourselves from adverse development. And that's really basically fundamental stuff in what we do, Tim.
I was just going to ask Michael and Adam if you've seen a situation where, and similar to the one that Michael just described, where there's 25 problem sites. Have you ever seen the rep and warranty policy not even include the excess coverage that Adam described? In other words, exclude all environmental.
I have. Yeah. So that could come up in a couple of ways. One is the most often or frequent way that you see that is when you have simply a very, very sensitive, environmentally speaking, target business. It would be expected for insurers simply when we go out and obtain quotes to respond in their quote that they're just going to exclude environmental insurance and say, listen, this is entirely the wheelhouse of the environmental insurers. We're not going to touch that because, frankly, it could be a very tricky proposition even for an environmental underwriter to underwrite certain businesses. We've seen that on just, for example, certain upstream oil and gas deals where the insurers will just outright exclude environmental liability for those transactions. But again, going back to the concept of putting the buyer back into the position that they would have been in the absence of rep and warranty insurance, Craig, what you typically see in the absence of rep and warranty insurance is some kind of environmental true-up. The product still probably accomplishes that goal while still acknowledging that it's not a very good solution on the environmental front.
Yeah, and just add real quick to what Adam said, Tony. What we like to also do that helps the client and the counsel is when we have that type of situation, there's probably about 10 to 12 insurers in our space that have both strong reps and warranties and environmental teams. We try to bring it together and leverage that with the goal of maybe we can get some cost, reductions by getting, knowing they're going to get two big policies, but also making sure there's none of these gray areas when there's claims, which is really important.
Yeah, it seems like it would be absolutely crucial to make sure that your RWI policy and your straightforward environmental insurance policy are flush with each other, right? And so that's kind of the responsibility of counsel, the insurance folks, and the client's team itself.
Well, I was going to say they are flush almost just by the terms of the rep and warranty policy, because to the extent it is covering pollution issues and environmental issues, it typically will just simply follow whatever the underlying policies are. And what I was going to say, I was trying to think if I've in 25 or so deals, if I've seen one where environmental was completely excluded, and I may have, but what I typically see, I think, is what Michael sort of just described, is where we push on them, the brokers push on the rep and warranty carrier, and ultimately, if the buyer can cobble together some kind of pollution insurance program going forward, we can get the rep and warranty policy to cover excess of that. But again, it's only going to be whatever's being covered underneath.
So, Daniel, this is Tim again. I think there's a really important takeaway here. A lot of our clients, in-house at companies will do a deal a year or a deal every 2 years. What we do on the outside is, dozens of deals a year. And so we're seeing this a lot. I worry that, maybe sometimes our in-house counterparts might not be fully aware of these sort of wrinkles and nuances on the insurance. They may hear, hey, there's a reps and warranties policy, and think, oh, great, we're covered. If there's a breach, we can recover that from insurance. That's not the way this works. And so it goes back to all of the traditional lawyering and diligence and negotiation on the environmental terms. You can't just offload this the way that you may offload some of the other items that are covered by RWI. And you've got to do some very sophisticated analysis of what the environmental concerns are and how the combination of RWI and environmental policies will be able to cover those issues. And sometimes they're not going to fully cover them. I mean, everybody knows the insurers won't write a policy on a house that's already on fire. When you're buying stuff that's messy and it's known to be messy, you need to find ways to contractually get protections for that. The facets, those different legs of the stool, all need to work together as you're developing your strategy as a buyer in the deal world. RWI, environmental insurance, but also just all those traditional tools that you use to negotiate environmental protection in the deal world.
Yeah, I couldn't agree more, Tim, the way you said it. And we at Marsh have to be, proactive and innovative in all those areas too, and pushing the deal team, saying, listen, you're not going to get the home for it on the rep side. It could be on the environmental side, but we've got to make sure everything's transparent in that process.
Sure. And thank you. And I'll just state that Adam's description at the outset of how these policies work with respect to environmental exactly matches my experience on a number of deals. So that was helpful.
Well, thank you all. Thank you, Tim, Tony, Adam, and Michael for the discussion today. I think there's plenty more we could explore, and we may do a follow-up sometime in the future and touch base and see just how this world is evolving. But for now, thank you all. Thank you especially to our guests from Marsh. And thank you, dearly beloved listeners, for tuning in. If you haven't already, be sure to subscribe, leave a glowing review, and feel free to reach out to me with questions or suggestions at daniel.pope@bracewell.com. We'll talk to you again soon.